evening, friends. And once we have a speaker like Mr. Uday Holla, Uday, as we all know that it means rise. We all know that Mr. Holla always rises to the occasion. And people keep on watching his YouTube sessions. And so much so that whosoever comes to our office also, we say that you should watch the sessions and knowledge shared by Mr. Holla. And today's session, though, we have written Relevance and Art of Cross-Examination. Mr. Uday Holla, a senior advocate, a former Advocate General of Karnataka. The relevance of cross-examination, needless to say that whosoever is associated with law would feel that they can make, mar, or demolish their case in their own manner. So that is why they say that cross-examination is an art as well as science. In fact, while we were delving upon the topic, we also thought as to whether there is some semblance of art and science as such. After a lot of dabbling of the topic, we finally narrowed down the topic, and we are glad that Vikram and Associates have also connected with us for this session. And thank you, sir, for accepting our invite as usual, and we are looking forward for your knowledge being shared today. Thank you once again. Over to you.
Well, friends, good evening. On a Saturday evening, when most of us will be roaming around in the malls or parks or with spending time with the family, it's good to see all of you here. Well, US Supreme Court in the matter of Maryland versus Craig, which is reported in 1990, SCC Online USSC 135 and paragraph 14 has held that cross-examination is the greatest legal engine ever invented for discovery of truth. Karnataka High Court has reiterated this in a judgment which is reported in AR 2003 Karnataka 293 at paragraph 8. The provision of cross-examination is found in the old Evidence Act 1870, Indian Evidence Act of 1872, paragraph 137 to 164. The equivalent provisions you will find in the Bharatiya Sakshya Adhiniyam 2023 at paragraphs 142 to 167. Section 137 of the old Act, the equivalent being 142 of the Bharatiya Sakshya Adhiniyam 2023, defines cross-examination to mean a witness, examination of a witness by an adverse party. Cross-examination is a tool which enables the opposite counsel to elicit information which supports his client's case, to efface the statements that have been made by the witness which hurts his client's case, and also discredit that witness. In fact, a century back, when Cox, one of the authors, he stated that cross-examination is better than oath. And that assumes all importance in present-day setup and society, where the litigants feel that whoever lies best in court succeeds. It's a sad part of reality. It is in this background that cross-examination assumes all importance. In every litigation, whether it be civil, criminal, arbitration, writ proceedings, in exceptional circumstances, oral evidence is recorded. In most of the writ petitions, there's no oral evidence at all. You will find a judgment of Justice Krishna Iyer way back in 1979 where a cross-examination by the High Court was referred to in the judgment of the Supreme Court. Oral evidence would necessarily include cross-examination. Reason is simple. If you do not cross-examine, you are deemed to have accepted what has been stated by the witness on behalf of the opposite party. In fact, the art of cross-examination, the ability to cross-examine is absolutely essential for lawyers. Even in the biggest of arbitration proceeding, one is required to lead evidence. Most of the arbitration cases, except in rare exception where parties will decide to rely only upon documentary evidence, there will be cross-examination chief, cross-examination and re-examination. The relevance of cross-examination, if we consider how is it relevant, that again assumes importance, because as the topic itself shows, we are dealing with relevance of cross-examination as well as art of cross-examination. To find out the relevance, one is required to ascertain as to what are the needs and the problems that a litigant faces. One of the major problems amongst human beings is greed, hunger for wealth and power. And in our society, this is compounded by the fact that value systems are eroding day by day. That is why I said a litigant today feels that whoever lies best in court succeeds. Therefore, cross-examination is a very important tool to ferret out the truth. In India, perjury is never taken seriously. That's a sad part. When banks file suits, first thing that the written statement will say is, I have never borrowed the money. The defendant never borrowed the money. And even if he has borrowed the money, this is not the amount that is payable. He has returned the entire amount. This is the way it goes on, despite the fact that the written statement today is required to be supported by and verified by an affidavit. In the Western nation, in the Western world, perjury is taken very, very seriously. In fact, that famous novelist, Jeffrey Archer, he was hauled up for perjury. He filed a case against a newspaper, Daily Star, for defamation. He succeeded in that case. There was a huge award in his favor. Ultimately, it was found out that he had lied under oath when he tendered the evidence. And ultimately, he was jailed for 4 years, though he may have come out for good behavior a little earlier. And of course, being what he is, he wrote 2 more novels, Prison Diary, and made millions out of it. But the fact is, in India, perjury is never taken seriously. In fact, we all know that the president of US, the earlier president of US was hauled up not for inappropriate relationship, but because he lied under oath. That is how the Western world looks at it. But we have a different mindset here. That is why I said today cross-examination assumes all importance, and it is absolutely essential and relevant in the present day context. The cross-examination is an art which can be imbued only by practice. That is the reason why I always tell new entrants to the bar to practice in the trial court at least for about 2 or 3 years. Because as I said, today arbitration is assuming importance. And when one goes for arbitration, even the biggest of arbitration where the stakes involved may run into thousands of crores, one is required to cross-examine the witnesses. The object of cross-examination has been commented upon by the Supreme Court in 2016, 3 SCC 108. In paragraph 20, Supreme Court held that cross-examination is to elicit admission of fact, which help the cross-examining counsel to build up his client's case and to discredit the witness of the opponent. This is one of the objects. In Kartar Singh's case, the Supreme Court that's a judgment, which is reported in 1994, 3 SCC 589. In paragraph 278, Supreme Court said that cross-examination is an acid test of truthfulness or the statement made by a witness in the examination in chief. And the object of cross-examination are, firstly, to destroy or weaken the evidentiary value of the witness or the adversary. Secondly, to elicit facts in favor of cross-examining lawyer's client from the mouth of the witness or the adversary. Thirdly, to show that the witness was unworthy of belief by impeaching his creditworthiness. And lastly, to test the veracity and shake the creditworthiness of the witness and injuring his character. I can only give you some illustration of how cross-examination is extremely important. Years back, a newspaper in UK, which is a 100-year-old paper with extensive sales across the globe, filed a trademarks case against another newspaper in India. I had the benefit of representing the Indian company. You can imagine the newspaper of the Western world based in UK was a 100-year-old paper. The very name had been used by the Indian paper, which was hardly 2.5 years in the market. In the normal circumstance, the UK newspaper should have won the case hands down. But unfortunately for them, the witness for the plaintiff, 2 of them came down to Bangalore. Both of them were in the witness box for about a month each. Ultimately, in the cross-examination, they admitted that Indian laws do not apply to them. They need not follow the Indian law. That they have not been in the Indian market, which is absolutely essential for you to sustain a suit for trademark. Therefore, ultimately, their suit came to be dismissed. Why I am giving you this example is that cross-examination is a very, very important tool which enables a party to succeed in a case. Many a times, if you know the law, you are in a better position to cross-examine a witness. In a suit for specific performance, which was filed, The plaintiff got into the witness box. I had the privilege of cross-examining him. The law on specific performance is that the person, the plaintiff, must always be ready and willing and continue to be ready and willing to perform his part of the obligation. And one of the important aspects of readiness and willingness is availability of funds to pay the sale consideration. The plaintiff's lawyer got his bank statement marked in evidence. When I came to cross-examine him, the witness thought there will be fireworks. But in reality, I knew what the law was. So all that I asked him was, the entire funds that you have is in the statement of account that you had produced, is it not? The answer was yes. That bank account had a 1.5 crores of amount, whereas the balance sale consideration payable was about for about 7.5 crores. So on that basis alone, on the ground that he was not ready and willing to perform his part of the contract, the suit came to be dismissed. Why I'm mentioning this is, if you know the law, you are always in an advantageous position. You can tailor make your questions based on the law. And if you know the law, you will be in a better position to get answers which help your client, and you are sure that the law as well helps you. How do you go about cross-examination? This is, if I can say, either the science or the art of cross-examination. 1990, there was an air crash in Bangalore. 90 people died. Air India, flying from Bombay to Bangalore, crashed near the airport, hardly 200 meters behind the runway. It crash landed. In fact, it crash landed on the golf course, hopped up, then 200 meters before the runway it landed, and it caught fire. Normally, whenever there's an air crash, there will be an inquiry. And normally, it will be headed by a High Court judge. In this particular case also, one of our High Court judges, Justice Shiv Shankar Bhatt, was appointed as the chairman, and 2 other assessors were there to assist him. The aircraft manufacturer, Airbus, the engine manufacturer, Aero Engines, the Air India, the Pilots Guild, all of them were represented, and everyone was trying to blame the other. In such a situation, one is required to do a lot of study, because you will be cross-examining persons on technical issues which you are not familiar with. Therefore, I had to sit with people who are experts in aviation industry and study the subject for nearly 6 months. Ultimately, I was able to cross-examine the witnesses and was able to show that the crash occurred because of the pilot error. The plane was supposed to be at 130 knots, equivalent to about 130 miles, when it was about to land in the runway of the airport. But it had gone down to 103 because the pilots were negligent and they were chit-chatting. Now, to cross-examine the witnesses, one had to know how the plane flies, what is a black box, what are its parameters, what does the black box do, what are the ailerons, the wings have had fuel and that caught fire and therefore people died of asphyxiation. So every aspect relating to the aircraft, about its flying, had to be studied. That is the challenge in this profession. But the truth of the matter is, cross-examination enabled the aero engine to prove that they were not at fault and the crash occurred because of the pilot error. Examples can be galore. There are different ways of cross-examination. Some people shout at the witnesses and try to browbeat them. Some people smile, disarm the witness, and get confessions and admissions. To me, the person who smiles and gets admissions is a better person, because the witness will always think that the cross-examiner is his friend and be more truthful. Whereas when start shouting at the witness, he'll get into a shell and he'll be more wary. In fact, various methodologies of cross-examination is an aspect which one learns from sheer experience. Initially, within 2 years of my coming to the bar, one of my friend who was in the trade union movement and one of the leading trade union leaders of Bangalore was hauled up in a criminal case. The charge was that they threw stones at the police and therefore they were charge sheeted. The police inspector was their prime witness. He got into the witness box and said, XYZ, including my friend, threw stones at him. That there was a morcha was undisputed. It was in the papers. That the police were there is undisputed. So how do you go about it? The only way one could do is somehow discredit that witness. He said, that inspector said, oh, these people threw stones at me. In such a situation, what do you do? One thing that a cross-examiner must remember and try to imbibe is, try to understand the human psychology. So one of the things that any witness will do is try to exaggerate the whole thing. So I asked that witness, look, you said, they threw stones at you. Must have been about, I pointed out my hand, made it look very big. I said, it must have been about 6 inches of stone. He said, no, sir, it is about 9 inches of stone. Fortunately for me, he had not said that he was wearing a helmet. So I said, 9 inches of stone, it fell on your head. Very good. Then he suddenly realized that, he had fallen into my trap. So he said, sir, I was wearing a helmet. If a 9-inch stone thrown at the head of a person who wears a helmet, necessarily the helmet will be dented. Neither the helmet was produced, nor a dented helmet, normal helmet was produced, nor a dented helmet was produced. So the resultant position was that the witness was found to be untrustworthy, and therefore my friend and others were acquitted. That's why I said there are various ways of going about cross-examining witnesses. There's no single path. Like propitiating the god, you propitiate the gods in different ways. So is how you do in cross-examination. But one thing is certain, you must study the person, you must understand the human psychology, you must know the law, in which event you will be in a better position to cross-examine a witness. Are there any particular methodology of cross-examination? There is no such thing. But one thing is certain. In our field of litigation, you come across different varieties of cases. As I said, I had dealt with the air crash. I had to sit with the experts, study about plane, how it flies, and the entire aspect relating to aircraft and its operations for about 6 months. A similar situation arose when I had to appear in a water dispute between the 3 states, southern states. A triple PhD IIT professor was witness for the other was the witness for one of the other states. I had to cross-examine him. He had spoken about scientific principles of water percolation, civil engineering, global warming, and a whole facet of scientific principles. We are ignorant of it. So what does one do? I got 3 retired Indian Institute of Science professors. So in the evening, I would sit with them from 6 o'clock to 12 o'clock in the night, assimilate, get as much information as possible on these scientific principles, assimilate them. Thereafter, from 12 to 3 in the morning, I would sit and prepare a questionnaire. And ultimately, I was able to cross-examine the witness and was able to show that every scientific principle he had enunciated was wrong. In fact, he had himself written number of papers. So we got them all. And what he deposed before the tribunal, Water Disputes Tribunal, was contrary to his own papers. Therefore, study is very, very important. Are there any particular rules with regard to cross-examination? I would say no. But there are certain golden rules that I would say are required to be followed by a cross-examiner. What would they be? Firstly, one must study the entire factual matrix pertaining to the case. If one studies the factual matrix, one is in a better position to cross-examine the witness. Secondly, one has to be brief. The witnesses have to be, the questions that are posed have to be in the form of a questionnaire which you prepare the previous day based on the examination in chief and the pleadings that have been put forward by the parties, as well as the evidence that have already been tendered. If you do not prepare the questionnaire in the hustle bustle of the cross-examination, you may tend to forget certain of them, certain important questions. Therefore, a questionnaire being prepared well in advance helps you in being precise, concise, and be able to be complete in your cross-examination. This is the second aspect. But once the cross-examination starts and you pose a question, witness may say certain things. You may have to ask further questions which are not in your questionnaire. That you must be able to do. That is why they say you must be able to think on your feet. That again is from sheer experience. Thirdly, elaborate questions will confuse the the witness, confuse the judge. On the contrary, short, precise questions will elicit better answers. One of the important aspects of cross-examination that every cross-examiner must remember is one must be sure of what question to ask. One must anticipate what answers could be given by the other side, by the witness. Based on that, one has to decide whether that question should be posed or not. Fourth, when a witness gives certain admissions, never show a glee in your face, never show a smile or a sense of victory. A deadpan face is what is needed, because the moment you show glee, moment you show, after all, the witness will be examining you as much as you examine and study the witness. He'll also be studying you. The moment you show that his cross-examination, his admission is a thing which is in your pocket, and therefore you are extremely happy, he'll immediately perceive that he has made a mistake. Then he'll try to water down whatever admissions he has given. Therefore, a deadpan face, if I can use that expression, without indicating any happiness on your face, will yield better results. Fifth, never ever shout at a witness unless you think that he is prevaricating and you want him to come into the line. As I said earlier, a smile, taking the witness into confidence, giving him a sense of confidence will always yield better results, because he, after some time, thinks that he's your friend. I remember years back, there was a witness whom I cross-examined. Initially, what you normally do is, you must ensure that he contradicts himself. The moment he contradicts himself and he realizes that he has contradicted himself, he loses his confidence. If he loses his confidence, he starts making mistakes, or he will start admitting to whatever you say. As I said, years back, I was cross-examining a witness. Initially, I was able to show that he had, I was able to show contradictions in his examination chief. How? The statements he had made contradicted his own pleading and contradicted certain documents. That resulted in his losing his confidence. And ultimately, whatever I said, he started saying yes. And my opponent lawyer ultimately had to tell to him that, hey, look, this counsel is not your friend, is your opponent. These are the ways of going about. Of course, as I said, it's a sheer practice that you learn this. Then, the other thing is, as I said, know the law. You are in a better position to ask the questions and to elicit answers which help you and which enables you to plead the law and show the law and the admissions that he has made, which will yield better results in the final analysis. These are the things that one has to bear in mind. Are there anything else that requires to be done? Yes. When you start shouting, of course, earlier, the trial used to be over before the same judge. It used to be taken up day to day. But today, with the prolixity of cases, the examination and cross-examinations before some judge, by the time the case is over, some other judge will be sitting to hear the final arguments. But a time may come when we go back to the old system where there is a continuity of examination, cross-examination, and the final summation, as well as the judgment by the judge. In such an event, when you become abrasive, you also take the judge against you. On the contrary, if you are of a friendly nature, smiling, courteous, judge also will eat out of your hand. These are various things that one must remember. Are there anything else that need to be examined, need to be borne in mind by the cross-examiner? Never ask a question unless you are sure of the answer and unless it is relevant. Because if you burk the deposition and keep on asking irrelevant questions, the relevant questions get subsumed in the surfeit of answers and the deposition and the lengthy deposition. You must also keenly observe the witness. If you observe the witness, you will be able to perceive as to whether he is telling the truth or he is lying. And if you are able to perceive that he is not truthful, you can probe him better and you can change the track. There is one more aspect that has to be borne in mind. The witness will always be prepared for cross-examination. His lawyer will have told him, look, read your examination in chief, read the pleadings, your own pleading. Questions will come in that order. So when you start cross-examining, if you go in a particular order, he will have come prepared. Therefore, somewhere midway, you may have to change the tack. When you perceive that he is tutored, that he is well prepared, somewhere in the middle, you'll have to ask questions, random questions, maybe from the end of the pleadings, maybe from somewhere in the middle of the pleading, in which event he gets unsettled. One of the things that one must, as a cross-examiner, one must always bear in mind is, if a witness is extremely comfortable and he is very friendly with you, he perceives that he is your friend, he starts admitting. But if ultimately you find that he is not being truthful, that he is prevaricating and that he is not being truthful, then in that event you will have to unsettle him. How do you do that? That is when you start asking him questions whereby he will be contradicting himself. When he starts contradicting himself and you show to him that he has contradicted himself, he loses that confidence that he has. Not only that, as I said, when you start random questions, he would not be prepared for the answers, or he would forget what answer he has to give, and therefore he'll be more truthful. Ultimately, as I said, this process of cross-examination is discovery of truth. And that discovery of truth can be elicited by various methods. Now, are there anything else that are required to be done? Ultimately, as I said, what is it that a cross-examiner is required to do? He is required to ensure that the witness's credibility is eroded. That is also equally important. Because if his credibility is eroded, then the judge will feel that his deposition is not to be taken on its face value. Therefore, you must not only study the pleadings, the factual matrix, but you must also study the background of the witness. That will help you enormously in cross-examining the witness. If you know that the witness is timid, your cross-examination tone and tenor will be different. If you know that he is extremely confident person, your tone and tenor will be different. Your questioning style will be different. These are all things which you learn from sheer experience. That's why my recommendation to all new entrants to the bar has always been, go to the trial court for about 2-3 years minimum. Try to learn the art of cross-examination. Even when you come go to the High Court, where other than the presidency towns of Madras, Bombay, Calcutta, and Delhi, you do not have original jurisdiction in the high courts. And there is an appellate jurisdiction. You will come in appeals, when you will be in a better position to appreciate the appeals, the examination and the deposition, if you know something about cross-examination, the art of cross-examination. One more aspect which must be borne in mind is always make eye contact with the witness. Give full attention to his manners, his body movement, his eyes. These will reveal as to whether he is being truthful or not. Your own composure as a cross-examiner, you must be in control of yourself. Moment you lose your temper, you will not be in a position to cross-examine the witness in the manner that you are required to and expected to. So calmness of composure of the cross-examiner, and to ensure that the witness loses his composure is what should be done. After all, in a football or rugby match, one of the things that the players always do is try to tackle. The man loses his temper, he starts, shouting, ranting, and ultimately gets into a foul, and therefore he is sent out of the field. So is the case with regard to cross-examination. After all, as I said, your whole aim is to ensure that the witness, you are able to elicit truth from that witness. Many a times, as somebody said, it's like extracting a tooth, an extremely difficult proposition. But that is what lawyers are required to do. Comprehensive study of the case law, also helps, as I stated earlier. These are aspects which must be borne in mind. Apart from this, these are aspects relating to, say, arbitration or civil disputes. Are there any difference in the way you cross-examine a witness in a civil case or a criminal case? Answer is yes. After all, a civil case, as I always say, is like making a pot. The mud is seasoned. Ultimately, it takes quite some time to make a pot. That is how a civil lawyer will go about his case. On the contrary, in a criminal case, it's like breaking the pot. If you are able to break the witness for the prosecution, you succeed in that. Therefore, the methodology of cross-examination in civil case as well as the criminal case varies. In a criminal case, maybe you will have to be more of a shouting type, because you have the police, You have persons who are trying to ensure that your client is convicted. To a little more aggressiveness is what is seen and what probably is needed than in a civil case. These are various aspects which I think, I've already taken over 45 minutes. Now, my friend will say, look, I think, there are a lot of people who are anxious to ask questions. So I think I will stop here. To put it in a nutshell, what are the golden rules of cross-examination? 1, study the facts, study the pleadings, study the factual matrix. 2, find out about the witness, his antecedents, what he is. 3, know the law. You are in a better position to cross-examine. 4, be sure of prepare the questionnaire beforehand. After all, when you sit and ruminate, you are in a better position to find out how you can ask the questions, in what manner. Preparation of questionnaire helps you enormously. Be sure of what questions you want to ask. Never ask a question without knowing the purpose for which you are asking. Never lose the temper. Be calm. Always be courteous. Always remember, as far as possible, whenever the witness is too confident, try and put in questions which will be whereby you are able to show contradictions in his evidence and show it to him, whereby he loses his confidence. Always study the witness. Never take your eyes off the witness. Study his demeanor. His eye contact must always be there. Maintain your calm. Maintain your composure. More than anything else, never be abrasive. After all, today he is your opponent witness. Tomorrow he may be your own witness. After all, your aim is to discover the truth. And in that connection, you have to do everything possible, but in the most courteous manner. These are the golden rules that I can think of and share with you. Thank you very much.
Thank you, sir. I will not say that they are golden rules. I will say they were actually a pot of gold. And how rightly you have put across. I was just reading somebody had shared his insights, that he said that there are 3 things basically essential. One is systems, which you have already said that how you have to arrange systems. Then they say that you have to have a particular skills or essential tools, how you generate into it, and then is the strategy. And I believe that those who have watched today's session, they will understand that these 3 S, which Mr. Rajiv Talreja has said, system, strategy, and skills, will actually help them to come out as a good advocate who is known for his cross-examination. I would like to ask you, somebody had sent me a text. Like you have said that there is a subtle difference between the cross-examination in a criminal case as well as in a civil case. You have given the example of the potter. Would it be more elaborative? What are the basic mindset to be changed during that process?
See, in a civil case, you will have to, as the potter, you will have to build up your case, which means that you will have to elicit factual matrix from that witness, which will help your client's case. And to ensure that he gives admissions which help in your client's case. Whereas in a criminal case, all that you are required to do is demolish the evidence that is given by the other side. You don't have to build up a case for your client. You will have to demolish the evidence that is given by that witness. So that's the subtle distinction that exists. In fact, one of the things that also one must remember is how to put suggestions. Let me give you one illustration. In a criminal case, if you suggest to the witness that my witness, my party XYZ was not there when the dacoity took place, if you put that suggestion, it implies that you admit that dacoity took place. So one must be extremely careful when you put across questions. This is so both in civil as well as criminal cases, but more so in criminal case. Then in a criminal case, ultimately, all that you have to do is destroy the credibility. Like that police inspector who exaggerated, the stone throwing incident and the stone that was thrown at him onto his head. In fact, he said it fell on the back of his head. So you exaggerate. That you may not do it in a civil case. Because there are various ways of going about it. That's why I said, how do you propitiate a god? There are innumerable ways. So is so. Each person, each cross-examiner has his own methodology, his own style, his own way of going about it. Well, this I thought, would be the subtle distinction between a criminal case and a civil case as far as cross-examination is concerned.
One said that another question was that do you believe that joining some good law office as such and watching him the art of cross-examination or what he does it, how does it actually help him to have a leverage in his profession by joining a good office for the purposes of understanding the purpose of cross-examination?
See, what happens is when you join a good office, there will be a variety of work. If, some offices, you will have trademark cases where again you'll have to cross-examine. You will have arbitration where, probably you will have diverse cases like engineering practice, civil engineering, dam construction, all that. That office may have property matters, specific performance, contractual matters, etc. Therefore, you will have a variety, one. Secondly, that office will be, the juniors and the seniors therein will be cross-examining. When you sit and watch performance, you learn a lot of things. After all, what we studied in the law schools and what we practice are totally different. We have all experienced it. When you sit and watch, it's not necessarily that you'll have to watch only your seniors. There are good lawyers who are adept in cross-examination. You must make it a point to go and sit when they cross-examine the witnesses. You will be able to perceive the manner in which they cross-examine and get a lot of insight into the art of cross-examination. After all, when we were young, and I'm sure other juniors also must be looking at it, even now, a good argument by a good senior, people will sit and watch. How does he argue? How does he tackle the judge? How does he, answer the questions that come up from the judges? How does he, after all, as I've always given the example, when you go into cricket, a person who is a well-known off-spinner is able to put the ball, spin the ball, and get the batsman out. But an ignorant like me, when I try to put a spin, it will go for a 6. But when I study minutely the spinner, the expert, I'll try to imbue part of it and I'll improve my technique. That is how you do it. Like A good cross-examiner, how does he tackle the witness? When the witness is hostile, how does he go about? If the witness starts, many a times what happens is, sometimes when the witnesses themselves, try to overawe the cross-examiner, how does the lawyer tackle him? These are things that you learn from examining, either cross-examining yourself or looking at experts cross-examining a witness. You learn a lot from looking at other experts who are cross-examined. Like if Nariman is arguing a matter, I'm sure we all used to throng to his court hall. Why? Because the way he argues, the way he puts across things, the way he tackles the judges, some part of it will imbue and try to emulate him. That is how it is done. So would be when a good cross-examiner, an expert cross-examines a witness. If I go and sit, I'll imbue certain facets of the cross-examination, certain methodologies that he uses. That's how it is, sir.
Yes, sir. Few
I
questions.
think, sir, we should take up this question. I think Mr. Vikas Chatrat, very interesting question, though he has asked little bit elaborative. Sir, what is the tactic that one has to adopt, especially when cross-examining in a family dispute? Because an emotional quotient would be involved.
It's very tough. See, in a family dispute, especially when ladies get into the witness box, copious tears will be there. So you will have to, ensure that, they don't start weeping. Because the moment there are copious, tears, first of all, you'll lose your cool and you'll lose your confidence to cross-examine. Secondly, it also has an impact on the judge. So what you will have to do probably is, you will have to, be more friendly with that witness in the initial stage, not, give an impression that you are threatening her. Very difficult. It's not easy. As I said, cross-examination is an art, which you, say, if I can use the expression, Bharatanatyam dance. Not everybody can do it. When we look at it, and if I start emulating, people laugh at me because I don't know the way, they do that, all the techniques of Bharatanatyam, the way they go about their hand movement, the leg movement. It's learned over the years from practice, from examining others, from looking at others, how they perform. It takes time. So in a family dispute, one thing is, as far as possible, try and ensure that the witness is calm. Because the moment they become emotional, especially women, they'll start weeping. Then, the sympathies will be there for them. You will also lose heart. After all, you can't be hard-hearted to, ensure that she weeps more. These are the things, there's, as I said, there's no hard and fast rule. Then and there, you will have to be innovative. That is only by sheer experience.
Sheer experience and practice also, like you said.
Yes, sir.
So Rishabh Bafna says, how to tackle witnesses who give their answers in general statements, like words maybe, may not, or I do not recollect, etc.
Well, the only way is, to show them the documents which they themselves are party to. That's why I said, when you study well or the entire factual matrix, if the man says or the witness says, I don't know, you will have to take out his letter, his own letters, and say, look, this is what you had said, isn't it? This is your letter, is it not? Answer will be yes. Then ask further probing questions. Then he has no choice but to say some answers and not, the same I don't know or maybe not. So study of the factual matrix is actually very, very important before you start cross-examining. It's like, if I can use that expression, the football match, beforehand, the coach will sit with them. He will have a diagram in what manner each of them should go about. I don't know whether you are aware of this. They sit, and in between also they'll come, stand together, they huddle together and they'll discuss. That is how, that is done. And that's what, will be done probably in the, with regard to the cross-examination. You'll have to, probably ask your witness, your own juniors who have read, far better than you, or your own client for some eliciting some answers. The only way is try and see that he contradicts himself. How do you do it? Well, once you study well, you are in a better position to do it. That's all I can say.
So the key mantra, what we also earlier discussed. So it is 3 P's: perseverance, persistence, and performance. One of the question is that what do you say that does the office or does the law background from which college he studied actually helps to evolve, or it is the desire and inspiration of that student or a law graduate?
If you ask me, a litigant lawyer, if he has had background of fight, he'll be in a better position to be a litigant lawyer. So would be the cross-examiner. In fact, I would say, this is what I've always said. If you have fire in your belly, you will come up. If you have pocket full of money, you will be satiated. Therefore, there's no need for you to struggle. Thankfully for me, my father was giving me 50 rupees. And initially, when I was the senior, no, he never gave me anything. Not one penny, not 1 rupee, 7 months. Thereafter, I started independent. I had no choice but to use my father's office. Out of pity, he gave me 50 rupees. It would not be sufficient even to, spend, for 5 days. My pride wouldn't permit me to ask money from him. Therefore, I had to struggle. So I would say people coming from the second tier cities are better will turn out to be better cross-examiners.
It is as good. There's an tagline of an ad which says "Jazba andar to dikhta hai bahar." So, Trikram, we can.
Before that, I think, Mr. Vikas, we'll have to thank many audiences who have joined today. Some of the prominent people. One of them is our friend, Professor Dr. Bolla, from principal of Kristu Jayanti College. Dr. Jayasimha, who is the principal of KLE Law College, has joined. And Professor G.B. Patil, who is the former Registrar General of the Karnataka State Law University, has also joined. And Justice Waghela has passed greetings to our respected senior, Uday Holla, sir. Sir, through this webinar, I'm just passing it on to you.
In fact,
Mr. Vikas, do you have it? Yes, please, sir.
In fact, today, because of the moot court, when we were in the law college, we didn't have moot courts. Today, moot court is a part of their curriculum. Therefore, they become better cross-examiners, though they do it in filmy style, whereas when they come to the court, it has to be slightly different. And therefore, they have these court visits and all that. So those people, those students are better prepared than how we were. That's one reality.
Very true,
thanks
sir.
to the professors who made it a part of the curriculum itself.
Yes,
Very true.
who actually go to the moots, and those who do this 1 month internship, they actually learn, and they also have whether they have to have the hang of this profession, whether they will hang in this profession, or so on and so on. So thank you, sir, for sharing your knowledge. It's always such a treat to the heart, eyes, and mind. It gives you a good food for thought. Thank you. Thank you, Trikram, for joining us. Thank you for the whole office who had made it all possible. Thank you, everyone.
Thank you, sir. Thank you, Vikas.